All right. Good evening, everyone. My name is Adam Carson. I am a principal planner with the Rockland County Department of Planning. I'm also the executive director of the Rockland Municipal Planning Federation, and welcome to session 2, the update of case law, featuring the very talented attorney, Christie Tomm. Just a little background, the Rockland Municipal Planning Federation is a nonprofit that's 35 years old. And one of its primary functions is to provide and promote educational programs so that land use board members can make more informed decisions about the applications that come before them. The certification program actually dates back to 1993. It was a creation of the Federation, and the towns, villages, and the county itself agreed to require their board members to take a series of 3 certification courses. Sessions 1, 2, and 3 are all given in the spring, and session 2, tonight's session, is given again in the fall. Before we get started, I do have a few housekeeping announcements. First of all, this session is unique in that we offer continuing legal education credit, or CLE credit. This is just for attorneys. If you're not an attorney and you don't need CLE credit, you don't need to worry about what I'm going to tell you. But the CLE Board of New York has some requirements that I need to follow, one of which was sending out the materials ahead of time, which you all hopefully already received. Also, throughout the night, I'm going to use attendance verification code words. These are code words that people getting CLE credit need to remember, so I suggest you write them down. If you are not an attorney, if you're not a lawyer, you do not need to worry about them, but please keep in mind that I will not be repeating them once I give them, and I'd ask everyone else to do the same. I'll be giving the first one shortly, so please get ready. Also, I'm obligated to send a course evaluation form and an attorney affirmation form by email after this session to every attendee, whether you're a lawyer or not. So you will be getting an email from me. Just expect it. And if you're not an attorney, again, you don't have to worry about it. Next, the Federation maintains attendance records. And as I said before we started, before I hit record, just being here, Zoom is tracking who is here and when, so I will have that information. You don't need to do anything else except stay logged in. If you are outside of Rockland County and you would like to get a certificate of attendance, please email me after this session. If you are in Rockland County or you're on the land use board, we keep a database of training. It will be updated and sent to your municipality. So you do not necessarily need a certificate. But again, if you want one, please send me an email and ask me. Last, your microphones are all muted. So if you have a question, please use the Q&A function. I'll monitor that and I will relay questions to Attorney Addona. Please keep in mind that she can answer questions about the cases being discussed or general areas of law. She is not in a position to give advice or opinions on specific projects or active legal actions in your community. So as promised, I'm going to give the first attendance verification code word now, and that is pumpkin, as in pumpkin pie. And tonight's session is kind of, I think of it as a good guide as to how, what are some of the legal pitfalls that boards can fall into if they're not careful. And I think we are very lucky to have Attorney Addona, who is very experienced with these things, to take us through recent court decisions and also provide us with some useful information as to how boards can avoid these types of problems. Christie is a partner at Silverberg Zalantis. She also advises municipal boards of the towns of Haverstraw and Ossining and the village of Tarrytown. She does land use applications. She works in litigation, appeals, Article 78 proceedings. She regularly lectures. She's done this session for us now. I know you split it with Steve going back for when I first started, but you've been going solo for about 5 years, I think.
Wow. Yeah, that's probably about right.
And she was acknowledged in 2018 through 2023 by the New York Metro Super Lawyers as a rising star in the area of land use and zoning. Christie has a bachelor with majors in economics and history from Swarthmore College, graduated magna cum laude from St. John's University of Law, and she's admitted to practice in New York, New Jersey, the Federal District Court of New Jersey, and the Federal Southern District of New York. So please join me in welcoming Christie. Thank you very much for being here. I'm going to go ahead and try to share my screen again, so we'll have that handout on the screen as we're talking.
Thanks, Adam. I just want to thank everyone for joining us this evening. I think we do appreciate, at least I do, being able to do this twice a year and being able to have it once in person and once remotely, because that might be easier for a lot of you all, especially today when we got some much needed rain and the roads may not be great. And Adam also mentioned Steve Silverberg, so who did do this before me and brought me into this, and who is on this. So I will give him a shout out, because I wouldn't be doing this if it wasn't for him, and hopefully I can try to live up to his standards. So I think hopefully a lot of you have been with us on this before, so I'll just do the brief recap. I think Adam touched on most of it. Most of what you're going to hear tonight are case law that's come out in the last year, and it's mostly challenging a determination made by a municipal board or official. So it's either a property owner challenging an unfavorable determination, or a member of the public or a resident neighbor who's unhappy with a favorable determination as it relates to the development that has been made. So, and what I'll refer to that as periodically throughout this is an Article 78 proceeding. And I will stop to take questions periodically. Thank you, Steve. And if there's anything specific that we can't get to tonight, all of my contact information is in the handout that Adam's posting right now. And at the end of this 2 hours, I will probably be a little fried. So I just want to say now, happy Thanksgiving to all of you and your families, and we'll see you next year. So with that, let's dive in. Thank you, Adam, for handling the handout, and I'll just be going off of what you have and obviously my notes. So the first subject matter is site plan, subdivision, and special use permits, which are generally issued by the planning board, although we'll see in this section that's not always the case. But the first case that we're looking at does involve a planning board. It's the Chestnut Petroleum District Incorporated versus the Town of Mount Pleasant Planning Board. And in this case, the petitioner submitted an application for a special permanent site plan to redevelop a vacant structure with a gas station, convenience store, and a Dunkin' Donuts drive-through, which I'm sure we're all seeing more and more frequently these days, which is very convenient, but obviously it does come with its own planning issues. The main concern that was raised by the planning board during the review process and by the public related to traffic, and the applicant made considerable efforts to try to address those issues, including reducing the number of fueling islands on the gas station from 4 to 3, and making access to and from the property right turn in and out only. So you couldn't make a left turn in, you couldn't make a left turn out. However, despite those efforts, the planning board did ultimately deny the application based upon the traffic impact, and the applicant brought this litigation challenging the denial. So the standard for a special permit, as conveyed by the court, in deciding whether a particular special permit application should be granted, a local zoning board may make common sense judgments and utilize the personal knowledge and familiarity with the area possessed by its members. However, the denial of a special permit use solely because of general objection to the special use is arbitrary. And that's something that we'll see as a repeating theme throughout tonight, is there needs to be something in the record that the zoning board, planning board, whatever board is making this determination, has assessed beyond just members of the public saying they don't like something or saying there will be traffic impacts. There needs to be something behind that to substantiate and support those concerns. That being said, judicial review of a determination to grant a special permit or deny it is limited in what the court can do. So the court isn't going to reevaluate what the planning board, zoning board has done. They're going to look at the record and they're going to say, was there a rational basis for this decision? Meaning, was it illegal? Was it arbitrary and capricious? Was it an abuse of discretion? or was there a rational basis behind it? If there is a rational basis, then more often than not, it will be upheld. So this is a relatively unique situation. Well, I wouldn't say relatively unique, but the planning board denied the application, as I said earlier, on a pretty substantial record from the applicant, where they made a concerted effort to try to address and were able to demonstrate from their perspective that the traffic and parking impacts would be sufficiently mitigated. However, the planning board had their own consultants and their own review that they had done that said, we don't think that they did demonstrate that there won't be unsafe conditions. And so ultimately the planning board denied it. And even though there was expert evidence on both sides as it relates to the traffic issue, because the record at least supported what the planning board ultimately determined, then the court was inclined and did uphold that determination. So, and this is a recurring theme. If you've ever heard me do these before, I say it repeatedly: make your record, make your record, make your record, because that's the only thing that the court is going to be looking at. It's a very important part of what these boards do, is that the court is not supposed to be doing its own independent review. It's supposed to be looking at what the boards looked at. So if there's something that wasn't presented to the board or wasn't considered by the board or wasn't justified by the board, then the court isn't going to consider that when they're ultimately reviewing the appeal, whether that's an appeal from an approval or an appeal from a denial. So the next case is Moe's Motor Cars LLC versus the town of Ulster. And in this case, we had two petitioners, the owner and the lessee, where the lessee wanted to operate an automotive sales facility. In the town of Ulster, which is actually a little bit different than what I was saying earlier, it's the town board that made the final determination on granting site plan and special permit applications. And this is something that's designated by the local code, by the town code. In most municipalities in this situation, it would be the planning board, or for special permits, some instances, the zoning board. In this case, it was relegated to the town board. But before they did that, they referred the applications to the planning board for their review and recommendation. The planning board did recommend granting the application subject to compliance with the zoning requirements. In the course of going through this application process, the applicant had to seek a variance from the Department of State because they were going to be using the automotive sales business was going to be mostly online only, with only one employee, and they weren't regularly going to be open to the public. So normally there would be a requirement that you have to have certain plumbing installations on the property to accommodate those on the property. In this case, they applied for a variance to the Department of State, which oversees these types of building code issues. And the Department of State actually granted a variance to them that as long as they had a portable toilet and hand sanitizing stations, because of the nature of their operation, they did not have to have the standard plumbing supply. However, the town board, ultimately denied the special permit request and linked it primarily to this provision of the state law that required these plumbing requirements that the applicant had already obtained a variance from. The town board also separately determined that the basis for the denial was for the applicant failing to establish that there was a reasonable need to have an automobile sales facility. So in this situation, even though there is deference afforded to the municipal boards in these situations, as I mentioned in the first case, the court overturned the town board's denial and remanded the matter to the town board for further consideration. The court didn't give them the town board a directive as to how to rule once the application came back to them, but there was certainly a lot of hand-holding in this decision to make it clear what the court thought the flaws were in the town board's analysis. The court thought that there was a problem with the fact that the town board had referenced their denial upon failure to get this, have this particular plumbing, in saying that there was a safety risk, where there had been a variance granted from the state agency that oversees that. And as I mentioned earlier, they talked about how there was no demonstration by the applicant there was a need for this automotive sales business. But that's not the standard when you have a special permit. Once a special permit use, which is already part of the code, it's like a permitted use, except there may be certain requirements, a certain additional review associated with it. But once the court explains that once you have a special permit use in your code, it's, and I'm going to quote, tantamount to a legislative finding that the permitted use is in harmony with the general zoning plan and will not adversely affect the neighborhood. So once that standard is in place, that something is a special permit use, it is a relatively low standard to gain approval and a relatively high standard to justify a denial. And in this case, the court found that the town board, based upon the justifications they provided, did not satisfy those standards. So the next case is Akeson versus the Incorporated Village of Asheroken. And this case is a little bit interesting and unique in that it deals with a different type of permit than what we normally hear about, which is site plan, special permit, subdivision, which are all the ones that are directed by either state law or local code. But municipality is based upon their specific location, their motivation, their circumstances. They may decide to require additional permits for certain activities. You may have heard of tree removal, wetlands, steep slopes, all additional permits you would have to get above and beyond perhaps a site plan or subdivision approval. So in this case, we were looking at a waterfront municipality. So they required that property owners obtain a permit to construct a seasonal floating dock on waterfront properties. And two of the property owners, who are the petitioners, meaning they are the ones aggrieved, made the application to the Board of Trustees. So we're talking the legislative board. And that application was, like in the previous case, it was referred to a different board, in this case, the Environmental Review Board. And that recommendation from the ERB was to deny the permit. And so when it came back to the Board of Trustees for their final determination, that was the direction, that was the decision that was made. And so what I think is important about this case is that the court reiterated that, like we deal with these other cases that are more standard, site plan variances, subdivision, even with these other permits that may be specific to a municipality, they're still entitled to this deferential standard of whether the determination was in violation of lawful procedure, was affected by an error of law, was arbitrary and capricious. And so applying that deferential standard, the court upheld the denials as having a rational basis. The court also was asked to look at certain aspects of how the public hearing process had come about, because for many or all of you board members, I'm sure you've experienced that it's a relatively informal process, right? You have a public hearing and anyone from the public can get up and speak. They can submit a letter. And so the question in this case, in part, was what is the standard of that type of quote unquote testimony? And so the court basically explains that this public comment, public hearing period is intended to be informational. It's not required to be sworn, and it doesn't require a cross-examination. So someone can get up and make a statement. That doesn't mean that they're entitled or that they're obligated to then answer questions in response to that. So it's clear, although the court didn't get into it, that there was probably public opposition during these public hearings. And so the implication, as I see it from reading this case, and again, this is something I've mentioned earlier, but I mentioned it in prior discussions, I'm only privy to what the court said in these decisions. There may be, I'm sure there's hundreds and hundreds of additional pages that went into what those decisions are, but I only see when we get to the final outcome. But like in my perspective from reading this decision, I think that the implication was that there was public comment that opposed this application, and so the court was trying to a certain extent justify why this was allowed to why they were allowed to make the statements they did, and for the board to come to the resolution it did. However, this court, like the prior court, did reiterate that generalized community opposition cannot be a basis for denial. But in this case, the court found that the record justified that the denial was based upon the criteria that was enumerated in the village code for what was required for a dock permit. Again, because this was a type of permit that was different than your standard site plan, subdivision, special permit. And so this was all regulated and legislated at the local level. And the last issue in this case was that there had been subsequent submissions after the Environmental Review Board had provided their negative recommendation that it should be denied. And the court said, that doesn't warrant a different finding on this issue, because even with the changes that the applicants made, it still didn't address the majority of the adverse impacts that were raised by the ERB. And I apologize, there was one more other issue in this case, which was part of the reason why it jumped out at me, and that was riparian rights, because that's not something that comes up very often. It obviously has to do with access to water, and the court doesn't get into it in great detail, but generally riparian rights is that certain areas of water, surface water in New York, is held in public trust so that they can be enjoyed by everyone for recreational purposes. You could think about it in the context of the Hudson River. However, there are certain instances where riparian rights, where there's private waterfront property that does have separate rights in the navigable portion of the waterway. So in this case, the applicants here said that this was a violation of their rights. And the court didn't say you don't have these rights. What the court said is basically what the Board of Trustees did was an enforcement of the code. And what the code did was put reasonable restrictions on those uses, and that is permissible. So there was nothing unacceptable. There may have been rights that were not permitted to the greatest extent, but really you could say that about zoning in general, right? That's what zoning is. It's putting certain restrictions on how someone can use their property because that's what's appropriate in this situation. And that's what the court found was the case in terms of these alleged riparian rights. So the next case is Bali 2 LLC versus Pascal. And in this case, petitioner sought to subdivide a 5-acre parcel into 5 lots to develop single-family homes. And the access was supposed to be on what was called Davidson Drive, which is referred to in this municipality as a tap street. And so the way that they define tap is it's a dead-end street which may be extended in the future. And so to get approval to develop on such a street, basically a dead-end road that hasn't been fully developed yet, you have to get permission from the planning board. In this case, the planning board denied the 4-lot subdivision. And so the petitioner, the property owner, went to court to appeal that. And so this kind of brought up a unique standard in terms of what rights developers and property owners have in access. And so what the court said is an abutting landowner may only be deprived access to a public highway, which in this case it was. Public highway is used very broadly to use pretty much any street that's open to the public. If there is available a suitable alternative means of access to the public highway and the municipality proves that the denial of access is reasonably necessary in the interest of public safety and welfare. So you have to demonstrate that there's a suitable alternative and that the reason for denial is necessary for public safety. Here, the court found that even though the planning board was entitled to their deference, they satisfied the former standard, which was there was suitable alternative means of access, but they didn't satisfy the latter standard, which was that it was necessary to provide this denial based upon the interest of the public safety and welfare. And as a result, the court found that the planning board's determination was arbitrary and capricious and was affected by an error of law. And the court separately noted that the planning board had received public comment from the neighbors who opposed the application, but the letter wasn't provided to the applicant until after the public hearing had been closed, at which point the applicant had no opportunity to respond. So even given that the court found that the planning board's determination didn't hold up on its face, at the very least, the court said that there should be a new public hearing to give the applicant the opportunity to respond to the issues that were raised in that letter after the public hearing was closed. Are there any comments, Adam, or questions? No? Okay. Okay, moving on to area variances. Gabrielle versus Zoning Board of Appeals of the Town of Eastchester. A neighbor brought an Article 78 proceeding. I'm just going over this basically to provide the standard for an area variance, which I always like to go over with you guys.
I'm sorry, Christie, there was a question in the chat, and I would just ask people if they have questions specifically for Christie, use the Q&A. There's a lot going on in the chat, and I could easily miss something there. But we have someone's asking, what was the outcome of this, the last one?
We'll find out in 2 years.
We'll find.
Or we won't. That's kind of the nature of these things, and I'll kind of allude to it a little bit as we go through some of these other cases. Is that the challenge is that the determinations we're getting are pretty delayed from when these issues actually arose. So now we're going to go back. This applicant has to go back to the planning board for a further determination on their application. And if they're still not happy, then they have to restart the litigation process all over again. So that's part of the interesting part. And there's certainly been cases that we've gone through over the years that I've been doing this where they pop up again every 3 or 4 years. And I mean, it's very unfortunate for both the municipalities and the property owners that it takes so long to get to a resolution when you have this type of dispute. But and ironically, these are some of the quicker ones to litigate because it's done in the context of an Article 78 proceeding where you don't go through the traditional discovery process that you would for a lot of your other like commercial litigations or even torts. So I'm sorry I don't have an answer for you. It's just that I'm bound by the facts of what's presented in the court case, and because I'm trying to give you all some of the most updated information, these cases are relatively recent. So it could come back before us in the next few years.
So we'll look out for it in the spring session. All right.
So,
Since I've already interrupted you, I'm going to go ahead and do the second code word. Again,
okay.
This is a attendance verification code word just for attorneys who need CLE credit. The second code word is Apple. Okay.
Okay, so back to area variances. We started on Gabrielle. So the criteria, so area variance is basically a balancing test, weighing the benefits to the applicant against the detriment to the health, safety, and welfare of the neighborhood or community. And there's 5 statutory criteria, which are not all required to be satisfied and not all required to be addressed, although I do think it's better that boards try to address them all. But it's supposed to be a balancing of all of these considerations, which is whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by granting the variance, whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance, whether the requested area variance is substantial, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district, and whether the alleged difficulty is self-created, which the state statute which applies to both villages and towns and cities, states that the self-created hardship is relevant to the decision, but not necessarily preclude the granting of the area variance. So in this case, we were looking at area variances that were challenged, that were approved for a residential apartment building. And the court noted that even though the variances were arguably substantial and the difficulty was self-created, because the other factors balanced that out, so to speak, that the record supported there wouldn't be an undesirable change in the character of the neighborhood. There was no alternative to the benefit the applicant was seeking to achieve, and there would be no adverse impact on the physical or environmental conditions, that the zoning board, given the discretion that we've heard in the previous cases in these types of decisions, was still justified in granting the variance, and so it was upheld. In this case, what I think was a little bit interesting about it was that the neighbors who brought this litigation because they were challenging the determination claimed their due process rights were violated because their submission that they made after the zoning board had closed the public hearing wasn't considered. And the court looked at the record and said, well, there were 4 public hearings. You were there at 3 of them, including the last one. So you really had an opportunity to be heard in a meaningful manner and at a meaningful time. So I was actually a little bit surprised that the court gave such consideration to that due process claim, because obviously public hearing is a big part of a lot of what your boards do. And so I don't think as long as there's a public hearing, there shouldn't be a due process claim. And really, the boards have to close the public hearing at some point in order for you to have a complete record in order to be able to make a decision. So I would just be cognizant of that. But if you are going to close the public hearing before you make your decision at a different meeting, just be aware of the fact that for zoning boards, not for planning boards under site plan, but there's a default denial if a decision isn't made within 62 days of closing the public hearing. So you should just be aware that if you're going to close the public hearing before you vote, that there is this time frame. Otherwise, it could be deemed a default denial. Now, that's not necessarily a bad thing unless you want to have the opportunity to justify your reason for the decision. So the next case is Seaview Association of Fire Islands versus the Town of Brookhaven Board of Zoning Appeals. So in this case, we had 2 neighboring property owners, and there was a fence where the applicant's fence, there was a fence that encroached on the neighboring property line. So the applicant sought to relocate that fence to a more appropriate location that wasn't on the neighboring property. The applicant proposed for a fence that would be 6 feet high and that was 2 to 4 feet set back from the property line, which would be a considerable benefit considering the fence was already on the property line. But what the zoning board did is they made it more stringent and they granted the variance, but they said you have to be 5 feet back from the property line and the fence can be 6 feet high, but the top foot has to be of a non-solid permeable material so that there's light and air exposure. For reasons I don't truly understand, the neighbor who was getting an improved condition was the one that challenged it. And ultimately applying the area variance standard, it was the decision of the zoning board was upheld. The reason why I decided to even bring up this case tonight is because I always like to mention to the board that the ability to put conditions on an approval where it's appropriate and where it's supported by the record and what your statutory criteria is for making that determination, as the court found in this. So the next case is Margulies versus the town of Ramapo. And in this case, this is a little more fact specific. Klein in 2016 made an application to the zoning board for an area variance to construct a 2-family home and an accessory apartment on a 16,800 square foot lot. And I apologize, I try not to give too much information, too much like factual nuances, but that's all important because this was an undersized lot for what they were proposing. So they had a 16,800 square foot lot, and to do what they wanted to do, which was the 2-family home and the accessory apartment, would have required 20,000 square feet. The zoning board ultimately granted the variances for the 2-family, but not the accessory apartment. So then 4 years go by, and Klein comes back to the zoning board to construct the accessory apartment within one of the 2 existing residential units that had already been approved. And this time, the zoning board grants the application. So the issue here, as some of you may surmise, is the precedent that's been set by what happened 4 years ago versus what the zoning board just did. And so on the issue of precedent, the general rule is that if a board intends to deviate from prior precedent or substantially similar facts, which would be the case here, the board must provide an explanation. Here, there were inevitably similar facts because it was the same application just 4 years earlier, with it being denied in 2016 and approved in 2020. That being said, the court explained the zoning board may refuse to duplicate previous errors, not saying necessarily if this was an error in this situation, but it can also change its views as to what is in the best interest of the town, or it may give weight to slight differences which are not easily discernible. And 2 of the key items that the court picked up on in this case that distinguished 2016 from 2020 is that the applicant Klein had explained that his father-in-law had passed away, and so part of the need for this accessory apartment more now than in 2016 was in order to have his mother-in-law be able to live with him. And also, we've all been hearing in the last several years about the towns, the counties, the states, the increased needs and demands for housing, and how this would help accommodate that by creating additional housing, even though on a smaller scale. So that was the justification the zoning board provided. As it relates to the earlier case I was talking about with the type of evidence the board would consider, the court again was asked to rule on certain what they called hearsay evidence, meaning that it wasn't firsthand from the person who experienced it. So the applicant had explained that their father-in-law had died, but the zoning board just took them at face value without providing any documentation, which I think is completely reasonable. And the mother-in-law being able to come live with them, they didn't hear that firsthand from the mother-in-law, but from the person making the application. But the court found that to be appropriate in the context of a zoning board hearing. So now moving on to use variances, Gasparini versus Zoning Board of Appeals of the Town of Newburgh. Petitioner owned a property with a 2-story residential building. It was formerly zoned 1- and 2-family dwellings, but was rezoned in 1991 to only a 1-family. And then in 2017, petitioners bought the property and began renting it out as 2 separate units. Petitioner ultimately made an application to the zoning board to authorize the 2-family use. First, they argued it was a legal non-conforming use, which the zoning board rejected, and we'll talk about legal non-conforming in a little bit. And then alternatively, the petitioner sought a use variance, which the zoning board also denied. And in contrast to what we were talking about earlier for an area variance, a use variance is a much more stringent standard to have to satisfy. because now you're not just talking about modifying the dimensional requirements, you're talking about the uses that the municipality and their legislative board has already determined is what's appropriate for that area. So for a use variance, you have to establish that the property as zoned creates an unnecessary hardship. And so as opposed to it being a balancing test for an area variance, for a use variance, you have to satisfy all 4 of the following factors. And the first of which is where a lot of people get hung up, that the property cannot yield a reasonable rate of return if used only for permitted purposes as currently zoned. So you would have to do an analysis of all permitted uses in that zone, which may not be that challenging in this case because it was zoned single family residential. But if you're looking at a commercial use or some sort of industrial where there's an abundance of permitted uses or multifamily, you would have to demonstrate that every one of those uses you cannot earn a reasonable rate of return. And that has to be demonstrated through dollars and cents proof. So not just kind of what I was talking about earlier, not just someone getting up and saying, I need my widowed mother-in-law to come live with me. Here, you have to demonstrate dollars and cents proof that this is what your circumstances are and that you can earn a reasonable rate of return without it. And then the other criteria is the hardship results from unique characteristics of the property. So if you're on a block and they all look exactly the same and they're used exactly the same, it's going to be hard to justify that distinction. It wouldn't alter the character of the neighborhood, and the alleged hardship is not self-created. And self-created, in my mind, is a very big deal as well, because it's very hard to justify why a hardship wouldn't be self-created if you're applying for either an area variance or a use variance, where even if it's legal non-conforming, you can argue that you acquired it with that knowledge or the zoning changed, but that's something that I think is a big hurdle for a lot of applicants, especially in a use variance application where you don't have the discretion that the zoning board would have in an area variance. So in this case, the court ultimately held the applicant didn't satisfy any of the criteria, and that therefore the application was properly denied.
Excuse me, Christie, there's a couple of questions about the one we talked about before, the Margulis versus Town of Ramapo, if I could interrupt for a sec. Regarding the zoning board making a decision not following precedents, what does giving an explanation mean legally and otherwise?
Be as factually specific as you can. If the applicant is telling you that there's a precedent that you have to follow as a board, and you need to distinguish yourself from that, you need to be looking at the determination that was made previously and those application materials and assess how that determination can be distinguished. What makes that easier is if you have a detailed resolution for every decision that's made, because then it's easier to just go back and say, well, here were the board's justifications for this application, and here's why this application is different. This is the reason why I talked about the Margulis case, is because it is very unique that there would be different determinations, that there would be the same application before the board. Usually in my experience, there is something that you can point to that makes one application different from another.
Another question I think about that area variance, did the family have to prove that a family member will occupy the accessory apartment? I see that same person comments later, when I created a mother-daughter with a living space with a full kitchen for my daughter, I had to sign an affidavit.
A municipality can require that if they want to. There are separate regulations as they relate to accessory apartments or affordable housing units. We're seeing that more frequently, where you can have an accessory unit because it's supposed to be more affordable. You're supposed to be, and it's creating housing. So those can be regulated kind of in the context of what I was talking about earlier with, it's not the same, but with a dock permit or something like that, where it's not necessarily a variance, which was the case here, is that they needed a variance for the square footage because they didn't have the square footage for the size of what they were looking for.
And did they ultimately provide any proof that it was in fact this mother-in-law living there?
The court said they didn't have to. The court
Okay.
was okay with them not.
All right. And this is a question for the use variance case. What is reasonable in a reasonable rate of return? Is there a standard, like i.e. 5% or something like that?
It's not the highest and best rate of return. I can't tell you. It's up to the board members. I'm sure there is an abundance of case law out there as to what could be reasonable. It's not the highest and best. So if someone comes in and says, I can make more money if I do this, that's not the standard. But it's also not, it's somewhere in the middle, and that really is a fact determination. And that's why you board members exist, is to make those fact determinations. It's not the highest and best, but it could be incumbent upon the applicant to show what a reasonable return would be based upon another potential use. And then you would have to decide how far below that this applicant would have to be for it to be suitable. But it's certainly a very different, it's not, I could make more money doing this. It's, if I can't do this, if I can't have this commercial use in a residential district, I'm going to go underwater. Here are my costs. Here is what, and it's all relative, right? It's all based upon what the costs associated with the property are, what the carrying costs are, what you could get for the property. That's all. It's all relative to that specific situation. So I really can't give a specific answer on that.
So yeah, we've got a few questions and chats popping up now, so I'll just get into it, I think. In an area variance, does the applicant who claims financial hardship, does he need documentation?
That's not one of the criteria for an area variance. One of the criteria for an area variance is whether there is an alternative to the benefit that the applicant is seeking. So if the applicant is saying, well, I can't put this deck in my backyard because it would be cost prohibitive because of the way my property slopes or something like that, I think that having documentation from an engineer or a contractor to support that would certainly be helpful. But if the question is as it relates to the use variance, which is a reasonable rate of return, yes, you should always have financial backup for that, because it's by dollars and cents proof. That's what the law is.
Yeah. So I'm sure there are people who ask for area variances with money being, a deciding factor, because I mean,
Sure. Yeah.
I like to say you can build anything. It's just how much is it going to cost?
Right. Yeah. Whether there's the actual standard is whether there's an alternative feasible for the applicant to pursue. So if the applicant's argument is we don't have a feasible alternative because it is cost prohibitive, then I would say it's on the applicant to demonstrate that to the satisfaction of the board. And what the board is willing to accept as evidence in the context of an area variance is in their discretion.
There's a couple more about the area variance with, I believe, referring to the accessory apartment. In terms of the board changing its mind, would it matter if it was different board members?
Generally, if you have a precedent, you should distinguish why it's different. It's not. There's obviously an understanding and expectation that board members won't be the same, but there should also be some level of consistency in how the boards and how the municipalities operate. And like I said, these are such fact-specific cases that I really think you could always, I think even if you even wanted to say, I think in one of the cases when I was talking about the precedent, it was that the objectives of the municipality had changed, right? So in the time from 2016 to 2020, there was an increase in the town's housing needs due to population growth, and this was a way to accommodate those needs. So the board members may be one thing, but there's also changes in circumstances and changes in what the municipality values at that point in time, that as board members, as residents of the community, the court is giving you the discretion to be privy to and to have that sort of inside knowledge to apply to these applications. I think I need to, Adam, I'm gonna be here till 10:30 if I don't keep going.
All right.
I don't want to cut anyone off from asking questions, and I'm happy to stick around after, but
Okay.
yeah.
I think that's appropriate given
questions on this topic?
there is one more, but I think we could maybe wait till the end, and I'll,
Okay.
the questions in the Q&A
I'm happy
don't
to stick
go
around
away.
after.
All right. Sounds good.
Okay, so interpretations and legal nonconforming uses, Upper Delaware Hospitality Corp. Versus the Town of Tustin Zoning Board of Appeals. The building inspector issued a certificate of occupancy for a restaurant. A neighboring property owner appealed the issuance of the certificate of occupancy to the zoning board. And this is kind of an interesting situation, especially for you zoning board members, is that there's a provision in state law that the zoning board can unilaterally decide to hold a rehearing on an application. So in this situation, they had an application before them challenging an interpretation as to whether the building inspector appropriately issued a certificate of occupancy. And they ultimately denied that they adopted a resolution by a 4-1 vote, so a supermajority vote, that they said that the appeal was untimely. There wasn't a basis for them to consider it on the merits because it hadn't been brought in a timely fashion. You're supposed to bring an appeal of a determination by the building inspector within 60 days. However, later in this meeting, and it's unclear from the decision what precipitated this, the zoning board adopted another resolution, again by a 4-1 vote, to hold a rehearing at a subsequent meeting about this issue. So the restaurant owner, who was frustrated because originally he got a determination that his C of O was fine, now he's getting a determination that the zoning board's going to reconsider it. And so they challenged the determination to hold the rehearing. And so the law on this is in both village and town law at the state level. And it says the zoning board of its own volition can decide to hold a rehearing on a prior application. So there doesn't have to be an application necessarily made to them. It would have had to have been made in the past, already decided. But in order for the zoning board to do so, the decision to have a rehearing has to be decided by unanimous vote of all of the members present at that meeting. Definitely a quorum of all the members, but it doesn't have to be all the members of the board, just all of the members present at that meeting. Here, it was a 4-1 vote. So there wasn't a legal authority under state statute for them to hold the rehearing. And that was what the restaurant owner was challenging. And that was what the court ultimately determined. I will also just point out, although this wasn't addressed in the case, once you hold the rehearing, if it's determined to be held by unanimous vote, then you have to you have to change the determination of the board also by a unanimous vote of the board members present. So that is just kind of a unique quirk that that comes up. So the next case, Krieger versus Town of Southold. The building department issued a building permit for a petitioner to construct a 2.5-story house. So the top half-story was going to be unfinished with access via a pull-down staircase. Months later, they sought to amend the building permit to finish the top story and add a permanent staircase. Based upon that, the building department denied the application, determining that by finishing it and having the permanent access, it would be an official full story, which wouldn't be permitted because then it would be a 3-story house. So they appealed to the zoning board, and the issue was the distinction between the definitions in the code of a half story versus a full story. And the zoning board upheld the building inspector's determination. And so they went to court. And what the court said, and this is an important standard, is that generally in making an interpretation of the code, the zoning board's determination is entitled to great deference. However, when the question is one of pure statutory reading and analysis, dependent on accurate apprehension of legislative intent, there is little basis to rely on any special competence or expertise of the ZBA, and no deference needs to be accorded. So that based upon that standard, which is general deference to the zoning board, but under special circumstances, like in this case where it's just a statutory interpretation, what does a story mean? What does a half story mean under the code? The court determined that there was no basis for any sort of deference to be provided to the zoning board. And based upon that analysis, the court was able to engage in its own de novo, so to speak, review, not necessarily relying upon the determinations the zoning board had made, and started doing that by looking at the legislative intent. And in this case, the legislative intent was what the town board decided to do in enacting the local law. So without getting into the weeds of the specific issue, the court looked at the definition in the code of a half story and the definition in the code of a story, and found that yes, finishing that space would have made this space qualify as a full story. It also didn't mean it wasn't a half story anymore. So there was this overlap in how the code operated. And so that probably was something that no one ever really contemplated, right? When you're writing these codes, you can't think about every scenario that would have happened. You have to address them as they come forward. So in this case, the court said, well, zoning board, you said by finishing this, it became a story and it was no longer a half story. But the reality is that now it's both. So we're going to send it back to you, and you look at it and you decide that if the other factors for a half story are satisfied. There were different dimensional requirements. It has to be 5 feet. It couldn't be finished at certain ends. So basically, this is like the situation I raised earlier, where they're going to go back to the zoning board now, and if the applicant gets an answer again that they don't like, they're going to have to start this litigation process all over again, and then we'll be talking about it again in a few months. So it's a challenging process, but hopefully, once you get to that point, the municipality and the property owners are willing to try to resolve it.
All right, Christie, I'm just going to jump in really quickly for our third secret code word, and that will be pecan. P-E-C-A-N, pecan, as in pecan pie. All right, just for lawyers only. Thank you.
All right, so the next case, Town of Nassau versus Nally. The defendants owned four parcels that were operated as a junkyard in 1989. The town adopted a local law that junkyards are a menace to the health, safety, and general welfare of the community, and prohibiting their operation without a permit. In 2011, the town banned junkyards entirely. So this property owner continued to use his junkyard until 2018, when he was issued a violation, and then he wouldn't stop, so the town had to go to court. And so there were a couple of arguments that the defendant made. The first was that the junkyard use was legal non-conforming and that was therefore permitted to continue. And so the standard for a legal non-conforming use is that when the zoning ordinance is enacted, If a use is existing before the zoning ordinance is enacted, the use is generally constitutionally protected and will be permitted to continue, notwithstanding anything that may change after that. However, the owner, it's incumbent on the owner to establish that the use was actually legal non-conforming prior to the enactment of the prohibitive zoning ordinance. So I can't just go to the zoning board and say, I've been using as my property as a junkyard. Kind of like in the other cases where we saw that there was a considerable amount of faith and discretion given to what the applicants and the property and the public was saying. Here, the standard is that it's incumbent upon the property owner to demonstrate that they use that property, or their predecessor in interest used that property in a manner that was consistent with what was permitted before the law was changed. And it's not up to the boards to be able to do that. So that, I think that's an important point. In this case, the court found that even though they had demonstrated the property was used as a junkyard prior to 1989, when the law was changed that required a permit for the use before 2011, they didn't get a permit. So at the time that it was completely outlawed, they didn't have the proper permits in place, and so the court found it was not a legal non-conforming use, and so they could not permit that. There was no justification for the court to permit the use to continue. And so in this case, the court did ultimately enjoin the use of the property as a junkyard based upon the violation of the zoning law. There was also an issue where the applicant argued, or the property owner argued, that the town was violating his equal protection rights by selective enforcement. So basically, I'm applying the code to you, but I'm not applying it to anyone else. But such selective enforcement has to be based upon impermissible considerations, race, religion, intent, or an objective to punish or impede one specific person in bad faith, which is a high standard to satisfy. And here, the court pretty much accepted the town's justification that, look, we weren't trying to penalize this property owner any more than everyone else, but we're a small department. We have one part-time code enforcement officer and a limited budget. So we issue violations, but we have to decide who we go after more vigorously. And in this case, this property was having the biggest issues and was the most intensely violating the code. And so that was where the town decided to put their resources, and the court accepted that. Okay, so I think we're up to zoning now. Patel versus the town of Rhinebeck. So in this case, back in 2009, the town had gone through an entire comprehensive plan redoing, and then they generally, the comprehensive plan doesn't actually make the changes themselves. It sets the stage, or it shows what the objectives and goals of the municipality are going forward. So based upon that comprehensive plan, there were certain local laws that were adopted to put new zoning regulations and amend the town zoning map in place. So this was again in 2009. And as part of that rezoning, one of the petitioner's vacant parcels was rezoned from commercial to a neighborhood residential zoning. And then we're 12, 13 years later in 2021, petitioner, probably for the first time, although it's not clear from the case, learned of this litigation, learned that the property had been rezoned. Maybe they were trying to sell it. Maybe they were trying to do some sort of development with it. Again, it had been a vacant parcel. And then they realized that this zoning change had gone into effect. And so they went to the town and they said, hey, change it back. This doesn't make any sense. It's on the corner of a commercial corridor. There's no reason for it to be like this. And the town said no. So the petitioners, the property owner, brought what's called a mandamus claim, which is basically a relief seeking to compel the municipality, in this case the town board, because it's a zone text amendment, which can only be done by the legislative board, to change it back to commercial. So the standard for mandamus is that it's an extraordinary remedy, that's only available to compel ministerial acts, ministerial meaning that do not involve any discretion or require strict adherence to a rule or standard with a compulsory result. So it's basically, the example that comes up most frequently is issuing a building permit. If someone submits an application for a building permit and they satisfy all of the statutory criteria, there's no basis to deny it. So if for some reason the building inspector doesn't grant the permit, then that would be a basis to go to the court and say, can you please issue me a writ of mandamus so that I can get this building permit that I'm entitled to. In this case, the court held this was not a proper function of the mandamus relief, because not only are town board and all legislative board actions generally discretionary, but especially a local law, and one that involves zoning. And we'll talk about another case in a few minutes that involved that. So because it completely involved the town board's discretion as to whether to adopt a local law to amend the zoning chapter and the zoning map, there was no basis for the court to give that remedy under the nature of mandamus. It's an unfortunate outcome because there's, like I said, the petitioner probably didn't even know this happened. It was a vacant parcel. They probably weren't aware of it. But by the time they did, there was no remedy available to them, because so many years had passed. And we'll talk about that in a few minutes when we get to statute of limitations. So next case is Hudson View Company versus the town of Fishkill. In December of 2017, the town board entered into a memorandum of understanding with the developer, where the developer sought to rezone 16 acres of property for a multifamily residential project. And the rezoning could only be done by the town board, as we've talked about in the previous case. The memorandum of understanding, which was signed off on by both the developer and the town board, stated that the town board would not, quote, terminate its review of the developer's zoning petition and the project in general until it reaches a final determination on the merits in its legislative judgment regarding the best interest of the town based upon empirical data and other objective factual bases. It also stated that the MOU would be binding upon the party successors. So the issues here are that this memorandum of understanding compelled the town board to proceed with the review of the rezoning proposal until it got to the point where that there was a substantive decision that would be made, which would not be the norm. And then after that, they could only make a decision based upon certain factors, which is also not the norm, because the town board generally, and legislative boards that make these types of zoning decisions, generally have great discretion in how they decide to handle that. So in this case, there were two separate arguments. So you have your two issues. You have the fact that it controlled the process and it controlled the substance of the outcome. It didn't necessarily say, and this was a big thing that the developer focused on, it didn't say the town board had to approve it. It said that you can only make a decision based upon certain factors, which would necessarily affect how the determination would be. So based upon that, the project was going along for another 2 or 3 years, and then you had new elected town board members come in, and they said, hey, we don't think this is a good idea. So we're done. We're not going to consider this anymore. Which normally they would not have been an issue that they would have been entitled to do. The developers sued them because we have this memorandum of understanding where you have to follow this process and you're not following this process. And so the town pretty much said, well, we think that this MOU was invalid from day one because it bound future town board members who hadn't been elected yet, and it constituted impermissible contract zoning in that you were dictating the decision or the process that was going to be made before we got to that point. And so basically, the court agreed with the town on it's ironic because the town was the one that entered into this, but ultimately the court said, no, town, you're right, that this isn't valid. The term limit rule prohibits one municipal body from contractually binding its successors in areas relating to the governance unless specifically authorized to do so. And so one of the important distinctions that the court focused on was in what capacity is the municipality operating? Is it operating in a governmental capacity? We're talking about zoning, service, and employment contracts, or in more of a proprietary capacity, something that isn't historically handled by a municipality, like the operation of a golf club or the operation of a restaurant. Those are things that may happen in a municipality based upon property they own, but it's not what you would consider a traditional governmental operation. And so the court said in this situation, it was absolutely governmental. It was a zoning function. It was a local law function. It was about as clear cut in terms of being governmental as you could get. And so the town board that agreed to enter into the MOU did not have the authority to do that and did not have the authority to bind the subsequent board members. The developer who's trying to defend and hold up this MOU, he tried to argue that a different and more lenient balancing of public interest standards should apply. And this comes generally from the seminal County of Monroe case that people may have heard of. It generally comes up in the context of whether a municipality is bound by their own zoning or bound by another municipality's zoning. If you own property, if a municipality owns property in another municipality, then a determination has to be made what zoning, if any, applies. And generally, there's a balancing test that's considered in that regard. Here, the court said, no, we don't think the balancing test in County of Monroe applies, which is a more lenient standard because the issues that came up in that case that set that precedent and standard aren't applicable here. But even if they were, any risks that what the developer argued was that if they didn't have some sort of assurance when they started this land use process, which is going to be very lengthy, very costly, take many years, if they didn't have any assurance they were at least going to get to the finish line, have the opportunity to justify why their project was appropriate, then no one would go through that process, which I mean is a reasonable argument, especially given the very broad discretion afforded to legislative boards in doing zoning amendments. But the court, while acknowledging that risk, found that it had to be balanced against the constitutional rights of the populace to choose governmental leaders who support its position. So the issue here is really, you had the public elected these officials to be put in place, and they shouldn't just be placeholders from what was there 5 years ago. Otherwise, what is the point of democracy? And so that was the overriding theme of this case. And so the court ultimately held that it did violate the term limit rule. And along the same lines, it was, as I mentioned earlier, it was contract zoning because you were binding the applicant, they were binding the town board to follow a procedure and make a determination based upon limited factors That wouldn't have been the case if this MOU wasn't in effect. So the next case is Elizabeth Street Garden Incorporated versus City of New York, and I'm going to shout this one out as a Court of Appeals case, which is the highest court in New York. We don't get a lot of them, so there isn't really a lot of substance I'm going to talk about in this case, but like I said, it's always important when we see these come down in zoning cases. And what I thought was significant about it was that there was a property that was owned by the city that was contemplated for new development of a mixed-use building with 123 units, including affordable housing. One of the city departments, the Department of Housing, Preservation, and Development, did the seeker review and issued a negative declaration, which we'll talk about in depth in a little bit, determining there would be no adverse environmental impact. So petitioners, neighbors, residents challenged the seeker determination. Again, I'm going to talk about seeker later, so I'm not going to focus on it here. But in the course of the litigation, also raised the issue that the project didn't comply with the city's zoning requirements. And the court said this wasn't the appropriate forum to be questioning zoning compliance, because zoning compliance wasn't part of the seeker review that was looked at by the Department of Housing, Preservation, and Development as part of the seeker review. So there would have been nothing in the record or no reason for them to make that determination. And therefore, because the standard is generally, the court is supposed to be looking at what the municipal boards looked at in the first instance, there was no reason for the court to be looking at this issue de novo, so to speak, because the department hadn't looked at it. So I just wanted to bring that up. And then I think I'm going to do 301, and then I'm going to skip, or I'll summarize briefly the last one. So 301 East 66th Street Condominium Corp. So the Blood Center had obtained approvals to convert a movie theater in the city to a laboratory and blood donation center. There was an appeal challenging the change of zoning on the grounds that it was spot zoning. I'm sure this is something you hear about frequently. Spot zoning is defined as the singling out of a small parcel of land for a use classification totally different from that of the surrounding area for the benefit of the owner of such property and to the detriment of the other owners. The relevant inquiry is whether challenged action was accomplished for the benefit of the individual owners rather than pursuant to a comprehensive plan. So there's a lot more to spot zoning than just, are you changing the zoning of one particular location? You have to look at the objectives. You have to look at what the plans for the municipality are. In this case, the court found it was unequivocally not spot zoning. The court held the zoning board, that more than anything else, what this zoning change did was brought the property more into conformity than it was previously, because the life sciences industry was something that was very prevalent in that area, especially if anyone's familiar with the Upper East Side of New York, Manhattan. There's a lot of hospitals and medical centers that are located along there. So even though this may not have been 100% consistent with what was right around it, it was conducive to what was in the area. And so the court upheld the zoning. And so I'm going to skip over Lost Lake Holdings LLC. This was a carryover from the last one in the spring. It talks about the municipality's requirements for escrow for different applications, but it's kind of nuanced, and I think we're going to be short on time. Also, I just want to clarify, I'm happy to answer as many questions. I'm happy to stay here till 10:30. I just think that like other people don't want to. So I apologize if that came across differently when I said it earlier. Like I'll keep going till the end, but I know everyone else has other things to do. So is there anything we need to do, Adam, at this point? Otherwise, I'll just keep going.
There is a question. I think we can hold it till the end, so I think we'll power through.
Okay, let's go. So threshold issues. So I'll try to run through these quickly because for the lawyers who have been listening to Adam's keywords, it's helpful, but for the rest of you, it's probably not going to come up that often. So exhaustion of administrative remedies, O'Malley versus Town of New Windsor Planning Board. The property owner filed a site plan application to develop an industrial park. The town engineer reviewed the application and found it complied with the zoning regulations. The planning board granted conditional site plan approval, and then the neighbors brought an Article 78 proceeding challenging that approval. One of the challenges to the site plan approval was that the application wasn't zoning compliant, and the court rejected the procedural posture of bringing this litigation because it's Hornbook law that one who objects to the act of an administrative agency must exhaust available administrative remedies before being permitted to litigate in a court of law. So in this case, the town engineer in this municipality made the initial determination that it was zoning compliant. The appropriate administrative remedy would have been to appeal that determination to the zoning board. The objectors did not do so. Instead, they waited until the process got all the way to the end where site plan approval was issued, and then challenged the zoning compliance as part of the planning board process, which the court determined was not appropriate. And so if there's a means for an issue to be resolved at the municipal level, that is what has to be done before you can go to court. And because it wasn't done here, by the time the challenge was made, there was no remedy available to them judicially. So the next case is for rightness, Village of Pelham Manor versus Crown Communications of New York. The New York State Police and Department of Transportation entered into a telecommunications agreement to develop a cell tower. And the cell tower was still in progress in 2019. In 2020, they were still doing environmental studies. SECRA hadn't been completed yet. However, the plaintiffs, which were neighboring property owners who objected to the project, commenced litigation challenging. And in this case, the issue was whether or not it was too soon to be in court on this specific issue. And so it's a fine line to balance between exhaustion of administrative remedies, ripeness, and also statute of limitations, which we'll get to. But for ripeness, you need a justiciable controversy. So there has to be an issue that it's not hypothetical, contingent, or remote. And it can't be something that could be resolved by further administrative action. So you have to get to the point where you've done everything you can or supposed to do at the administrative level, but you can't go any further. And here they said that because there had been no approvals, no secret determinations that have been made yet, there was nothing left to do. There was nothing for the court to review. The reason why the action was actually brought when it was because of this agreement between the state and the town that basically provided for a default approval if there wasn't a determination made within a certain period of time. So here, what the plaintiffs, the neighbors were trying to do in opposing this was protect themselves and say, okay, well, if we don't go into court now, then potentially we could be told later on that we waited too long. And so they were prudent and they were conservative. And I think they were right, because you can always be told by the court you can come back later. When you exceed the statute of limitations, you don't have that discretion afforded to you, as we're going to see in the next case of Radcliffe versus the town of Nelson. So in this case, Hopkinson, which is the name of the property owner, sought site plan approval to construct a single-family home and related improvements. A lot of the property owners came out in opposition to the application, but the planning board ultimately did grant site plan approval. And then the neighbors brought an Article 78 proceeding challenging the approval. But what the neighbors did first, before they brought the Article 78 proceeding, is they appealed the planning board's determination to the zoning board. And the court found that that was procedurally improper. From the planning board's determination, they should have gone straight to court. there was no, an appeal to the zoning board comes from the administrative official designated with making the determination. In this case, that the planning, by the time it got to the planning board and that decision was made, there was nowhere else to go other than to court. But because they went to the zoning board first, they ran out of time, because the statute of limitations to challenge a planning board determination is 30 days of it being filed with the municipal clerk. Here, they spent so much time going to the zoning board and doing whatever else they were doing that wasn't referenced in the court decision. They didn't bring this litigation until 4 years later. So they were far outside. So then they talked about trying to argue why the statute of limitations didn't apply, because it was void as a matter of law, because they didn't comply with the statutory regulations. And the court rejected that argument, because the only reason that a municipal action would be void ab initio, to the extent that there would not be a statute of limitations, is if they acted in excess of the authority by the state in passing a law that exceeds the jurisdiction of the municipality. And this did not occur here. All this was a planning board granting site plan approval. And honestly, in my opinion, if the court had I thought it was a pretty unique argument to say that the statute of limitations didn't apply because the planning board didn't comply with the code. I've seen it before, but not necessarily in this general of a case. But if the court had agreed with them, we would have had a really big problem on our hands, because virtually every action that zoning board, planning board, legislative board in the context of land use of zoning comes from some sort of statute. So to say that the statute of limitations doesn't apply, if the argument is, without even proving it, that you didn't comply with the statute, then it would pretty much render statute of limitations meaningless in this context, which I think is very important, because it's a very short statute of limitations. And the reason for that is so that the municipalities can have the certainty of knowing that how something is going to be resolved, and that they're not going to have this floating over their heads. Here it was 4 years later, which is a very long time to start bringing another litigation about a land use decision. So I agree with that decision. And then the next case, Velarde Ward versus New York State Department of Environmental Conservation. Briefly, this is a case where it was a Department of Environmental Conservation wetlands permit that was being issued. They had a 30-day statute of limitations that was set forth in environmental conservation law, which regulated how the DEC operates. However, there are different statute of limitations that said that it was 4 months. So the applicant followed the petitioner followed the wrong, the longer statute of limitations, and ended up missing it because the court said it was 30 days, and they complied with the 4 months. So it's always better to be conservative and go in earlier. Like I said before, you can always be told you can come back later, but once you lose that deadline, you can't go back. And then the other thing that was interesting about this case is that they weren't only challenging the issuance of the wetlands permit, they were also challenging the SECRA finding, which ended the SECRA process, finding that there was no adverse impact that couldn't be mitigated. And so in this case, and the court said the statute of limitations commences once the determination becomes final and binding upon the petitioner. And often in the past, final and binding upon the petitioner is when they got some sort of permit or approval for was subsequent to the secret determination. Here, the court found that the secret findings in and of themselves was the final and binding determination. So it started from that point. So what the petitioners did in this case was they followed somewhat of the previous rule in that they challenged the secret determination at the same time the permit was issued. And the court said that because the secret determination had been made several years earlier, that had also expired, and so the petitioners had no remedy. In the interest of time, I think I'm gonna skip over Adam, I'm going to skip down to, I mean, everyone has everything in the handout that I was going to talk about, but we're supposed to wrap up at 9, right?
Yes, that's 8:32
Okay, so, yeah, so I'm going to skip down to freedom of information, like the standing, necessary parties, intervention, collateral estoppel. Those are all litigation issues. So if any attorneys or any board members who have any questions about it, I'm happy to talk about it, but I think it would probably be better for me to focus on the land use and board issues. So I'm going to skip down to freedom of information law, Lost Lake Holdings. Yeah, thank you. So I'm not going to go into depth about the facts on this, but this is something I wanted to caution you about. The petitioner was seeking to develop a 2,500 acre resort and residential community. And I guess the land use review process wasn't going well because the petitioner made a request pursuant to the Freedom of Information Law to the town for various documents related to the town's operations. As many of you may know, Freedom of Information Law means that records that are maintained by the municipality are subject to disclosure unless otherwise exempt, and there is a list of exempted reasons. In this case, what I thought was notable, I mean, the case was 7 or 8 pages long, and it went into specific factual depth about a lot of different areas. But the one that I thought was notable to the team here tonight is the fact that they had asked for any notes that had been generated by the planning board chair with respect to this specific project. But it wasn't just the planning board chair in his capacity as a planning board chair or at planning board meetings or dealing with planning board business. It was also any meetings with the town board, with the zoning board, or any town meetings outside of those board capacities. So the town denied the request on the grounds that it was too broad. And the court, I think, was trying to toe the line on this one. But they basically said, we can't accept that it was too broad as a justification for denying this. The court rejected this justification because FOIL responses, FOIL records would include notes, handwritten or typed, prepared in connection with an official government function. So it's not as narrow as you may always think it is in terms of what capacity you're operating in. So in this case, the court said, it may be that that the request is too broad. It may be that there are other exemptions that apply, but just saying it's too broad without giving us the records to look at isn't good enough. So the planning board chair or any board member, what this decision I think pretty much stands for is that if they have records, handwritten or otherwise, that were created in their capacity as a member or chairman or official of that municipality, that they could be subject to disclosure under FOIL. So I just wanted to make everyone aware of that. And it's a factual assessment. And if someone isn't If there's a dispute, it can be reviewed by the court, what's called in camera, where the court looks at it, but it's outside of the public eye. But yeah, the implication here is that any notes or anything that a board member does in their capacity for the municipality can be subject to FOIL and disclosure. So I'm going to try to jump through these quickly for State Environmental Quality Review Act, SECRA. So the first two, PG Equities, Inc. versus the Village of Ossining, and Carlson versus New York City Council. So the point of these two cases was to kind of distinguish how different actions are typed, so to speak. So everything that could potentially be impactful on the environment has to be looked at under SECRA. The DEC, the Department of Environmental Conservation, has a list of what's called type 2 actions, which are the ones that are automatically exempt and are not subject to further environmental review. Then you have the type 1 actions that are absolutely subject to environmental review and carry with them the presumption that there is the potential for a significant adverse environmental impact that would require the preparation of environmental impact statements. It doesn't necessarily require it, but there's that presumption. And then everything in the middle that isn't type 2 or type 1 is unlisted. So in this first case, PJB Equities, the Village of Ossining had declared a housing emergency and applied the Emergency Tenant Protection Act, some of you may have heard of it, ETPA, in the village. Excuse me. There was a challenge to this on the grounds that it was that there was an adequate seeker review because the village had determined it to be a type 2 action. But in looking at the seeker regulations from the DEC, it was very clear to the court that this was a type 2 action. Therefore, no further seeker review was required, and therefore there was no basis to challenge any sort of action or inaction, as the case may be, as it relates to seeker. And then contrast that with the Carlson case. In this case, the City Council, mistakenly identified a proposed school development as an unlisted action when it should have been a type 1 action. So as I mentioned earlier, type 1 action is one that has a higher risk of having environmental impact. And the reason why this particular one was a type 1 action was because of its close proximity to a church that was designated as eligible for listing on the State Register of Historic Places. So if something's eligible to be on the historic register, if it's near a park, if it's over a certain size, if it's rezoning over a certain size, there's a whole bunch of things that can make something a type 1, but that's why it was a type 1 here. So in this case, I don't think anyone disputed it was a type 1 in the litigation, but while the application was before the City Council, they considered it an unlisted action. And they ultimately issued a negative declaration that there wouldn't be any adverse environmental impact. So then the neighbors who were opposing the approvals brought litigation seeking to challenge the typing of the action and ultimately how the process was handled. And the court said, well, yes, we agree with you. It wasn't an unlisted action. It was a type 1 action. The city should have considered it a type 1 action. Okay, they didn't. So, but let's move forward from there. And just because it was called a type 1 action, called an unlisted action, what did that mean for the actual substance of the review? And in this case, the court said, you know what? We think the seeker review was still fine. Even though it was unlisted, the city basically went through the exact same process that they would have gone through if it had been considered a type 1 action. They prepared a full environmental assessment form, which is much lengthier than the short environmental assessment form, which can only be provided for unlisted actions. There were supplemental submissions that were made to the city to address what the potential environmental impacts were and how they were going to be addressed or mitigated to the greatest extent possible. So the court said, even though on paper, you should have put type 1 where you put unlisted, everything that happened after that was substantively proper to the point where it didn't warrant vacating or overturning the secret review that had occurred. The next case is Cedar Street Committee versus Board of Education of the East Hampton Union Free School District. So the school district had adopted a negative declaration pursuant to SECRA. And again, this is a determination that there won't be any adverse environmental impact, and therefore no further environmental review is required. And this was for a school bus maintenance depot. And in this case, the neighbors, which is often the case, brought an Article 78 proceeding challenging the favorable environmental determination. Again, like we've heard about in other cases, the court explained that judicial review is limited to whether the lead agency, here the school district, identified the relevant areas of environmental concern, took the requisite hard look, and made a reasoned elaboration for the basis of its determination. What's important, I think, about this case is that the court explained not every conceivable environmental impact, mitigating measure, or alternative must be identified and addressed in order to satisfy the substantive requirements of SECRA, and therefore the degree of detail with which each factor must be discussed will vary with the circumstances and nature of the proposal. So this isn't a hard and fast line that the court is trying to draw here. There's a certain standard. You have to look at the environmental issues. You have to take a hard look at them, and you have to give a rationale for how you're assessing them when you come to your determination. But you can't expect every single issue that someone may come up with, whether warranted or not, to be investigated in the level of minutia that when you're being challenged in court, the argument may be. The court also acknowledged that, as we discussed, it's not their job to substitute its opinion or judgment for the land use board. So as long as the record shows that those standards were satisfied under SECRA, the court will and should uphold it. And that's what happened here. The court found the Board of Education thoroughly reviewed issues such as noise, groundwater pollution, traffic, visual, and aesthetic impact. Even though there were some details that were lacking with respect to the location of the elevation, the court didn't think that precluded a determination on the SECRA review, so it was ultimately upheld.
Excuse me, Christie. I'm just going to jump in with the last code word for attorneys and their CLE credit. The fourth and final one of the night will be MUD, M-U-D, MUD. And you get extra points if you figure out the theme.
Okay. I'm gonna skip over Sierra Club. I'm just trying to get through the. So in Bennett versus Troy City Council, developer proposed construction of an apartment building on 11 acres of vacant forested land. The Planning Commission made a favorable recommendation on the proposed project. However, the City Council ultimately served as lead agency under SECRA and determined it was a type 1 action, which again carries with it the presumption of a significant adverse environmental impact. After the environmental review was completed, the City Council issued a negative declaration determining the project didn't have the potential for any significant adverse environmental impact. However, in this case, when the secret determination was challenged by a neighboring property owner who was unhappy with it, the court ruled in favor of the neighbors and found that the city council failed to take a hard look at certain issues. So there is a balancing between the prior case that we talked about and this case, where you're not expected to look at every single issue that could potentially arise at the greatest level of minutia. But at the same time, the court found that in the Bennett case, there were archaeological impacts associated with the Native American communities that had lived on the grounds and the historic significance of them that were not adequately considered, and that there were input of Native American community groups whose input was supposed to be included, but was not really given adequate consideration. And so the court felt that they really tried to downplay the significance of those impacts on this project. And so they ultimately said this secret determination can't stand because you really didn't take a hard look at the environmental impact. What's also interesting about this case is that what I think is important for everyone to understand, if you don't already, is that SECRA has to be done. If it's not a type 2 action, if there has to be environmental review, it has to be done before any subsequent permits or determinations, approvals, recommendations, anything can be considered. You need to have that environmental review done first. And so here, where the court said the SECRA review was not sufficient, that should have been the end of the conversation. But instead, the court actually went and looked at the challenge that had been made to the zoning determination, which came after, was subsequent to the SECRA determination that had been vacated. And so as it related to the zoning, there had been a challenge that it was spot zoning, which we talked about earlier, the process of singling out a small parcel. And the court acknowledged that the city's zoning determination was entitled to a strong presumption of validity, but it also has to comport with the comprehensive plan. And the court found that here it did. So you had a multifamily residential development that was in a single family residential area or a lower density residential area. So even though it wasn't exactly the same, it did continue to apply the residential aspect. And they also tried to make efforts to have it be a low impact design in order to accommodate what the current use was. So what the court basically did was told the city, you have to go back and you have to do SECRA more comprehensively. But once you do that SECRA, you're not going to have a problem with your zoning because I've already told you that I think it's fine. So that's basically what I took away from that conversation. From that decision. And then the last SECRA case, Binghamton Plaza Inc. versus City of Binghamton, and this is segmentation. So the city wanted to acquire a very large parcel, about 25 acres. It was a former strip mall that was in very bad shape. It had been dilapidated and not kept up. So the city wanted to acquire it by eminent domain. The city engaged in a SECRA review for the acquisition of the property, but didn't include, in the SECRA analysis, the potential redevelopment of the property. And so the argument here by the neighboring residents who opposed this acquisition and potential redevelopment was that it was segmentation. Segmentation is kind of like spot zoning, right? It's a scary word, and it could have potential implications. But it's not as cut and dry, or it's not as automatic, I think, as maybe it used to be, or there's a lot more factual analysis that goes into it. I'll say that, because the DEC regulations that regulate SECRA actually contemplate that segmentation, it's not the norm. You don't want to do it, but it can be permitted if the lead agency can explain how, or justify why they're not doing it as a coordinated review. Why aren't you looking at this entire project comprehensively? And if you can demonstrate that the future review of the second portion of the project will be no less protective of the environment than if it was done with the current project. And in this case, the court found that the city council could satisfy the standard to justify segmentation. There was no current review of the redevelopment because, frankly, the city hadn't gotten to that point yet. They were trying to acquire the parcel. They hadn't gotten far enough to figure out what they're going to do with it, but they know it's in bad shape. They know it needs to be turned around. They know they can make value out of it for public purposes. They're just still working through what that is. And sometimes when you're doing something by eminent domain, you don't have the benefit of time to wait because there's certain statutory procedures you have to follow. In addition, they had a site management plan which would dictate how any future development would work. It would also require approval from the Department of Environmental Conservation. So the city had put ample steps in place and protections in place and safeguards in order to show that if and when the time comes for the redevelopment of these properties that they're acquiring by eminent domain, that they have the safeguards in place in order to be able to ensure that the environmental review and the permitting that's done at that time will be sufficiently protective of the environment, and the court agreed with them. Adam, what do you want me to do here on timing? I could try to just do one of each of the following cases. Or do you want me to just keep going?
Sorry, I was muted. I was gonna say, I think our lupa is kind of the the dessert of the evening. So if you want to skip ahead to that,
that's fine. So if anyone wants to chat with me about Telecommunications Act, basically the gist is it's held to a higher standard. So if you have any questions about it, you should talk to your municipal attorney, or if you want to chat with me, I'd be happy to chat with you about it. But yeah, you have to justify your actions, and there are specific time frames. So anyway, okay. Religious uses. So St. Timothy's Episcopal Church by and through the Diocese of Oregon. So this is a church that was legal non-conforming. And then in 2009, they began serving meals to the hungry, along with other religious institutions. The city was aware the church was providing the service, but over the years, especially during the pandemic, the number of meals they would provide increased pretty considerably. And so at some point, from what I could tell from the case, the church started to let homeless people live in cars on the church property, which I think upset the neighbors and probably upset the municipality. And so there was a petition that kind of really started focusing on this church's operations. So about 12 years later, in 2021, the city amended the code to require a conditional use permit, which is akin to a special use permit for benevolent meal services, but they could only be served 2 days a week, whereas the church had been doing it pretty much every day prior to that. So the first question was, so the church in response to that brought a litigation that this was a violation of our LUPA. So for our LUPA, you need a couple of things. You need there to be a land use regulation or zoning regulation. And then if you have that, then you have to determine whether it's a substantial burden on your exercise of religion. So here was the service, the restriction on how frequently benevolent meal services could be provided. Was that actually a land use regulation? Was that actually a zoning regulation? And the court said, yeah, because it's akin to a land development code, and it takes into account the activities of the service, the use that is being provided. And then the question becomes, so does this relate to religious exercise under our LUPA? And they said there's no doubt that feeding the vulnerable is a sincerely religious belief. The court spent pages of its decision citing to the Bible that the church had cited to for support. So you have a land use regulation, you have religious exercise. Is it a substantial burden? And so then the question is, a substantial burden is one that's oppressive to a significantly great extent. That sounds like a pretty high standard. But when you put it into practice and you think about it in the context of what was happening here, that the church was feeding the hungry 6 days a week, and now they're limited to 2. And what the court actually quoted, which I thought was pretty compelling, by limiting the number of days per week that St. Timothy's can provide benevolent meal service, the ordinance forces plaintiffs to choose between acting in accordance with their faith or facing a fine of $720 per day. The ordinance thus puts substantial pressure on plaintiffs to modify their behavior and to violate their belief. And so based upon that, the court said, yeah, this is a substantial burden on your exercise of religion. And so it violated our LUPA. And then the court went a little bit further in evaluating, even if something is a substantial burden on the exercise of religion, if the municipality can then determine with their burden that there was a compelling government interest and that what they were trying to achieve was the least restrictive means of doing so, then they could potentially circumvent the substantial burden standard. Here, the court found that they really couldn't. Any justification the city tried to give, public welfare, maintaining peace, preventing crime, they could raise arguments for why it was compelling. They couldn't justify why what they were doing in limiting the number of days a week that they could serve the hungry, the church could serve the hungry from 6 to 2, was actually going to accomplish those objectives that the city claims they were trying to achieve. And so it was a violation of our LUPA. And then I'll skim Edgewood. So Edgewood High School of the Sacred Heart versus the City of Madison. So this is a high school that was over 100 years old, 1880s, that wanted to install lights on its athletic field. It was a religious private school, and the city said it wasn't consistent with their master plan, so they would have to get modifications to the plan for that. Instead, the school sought separate permitting, which was denied. The school's mission, stated mission, is to educate the whole student, mind, body, and soul. So they basically argued that having these athletic programs and having these lighting on their fields were critical to their operation. The neighbors started complaining about the hosting of games on the field, but they never really pursued a violation. Ultimately, it was determined that the lights would be an adverse impact. And so at that point, the school commenced a litigation claim. The first one they claimed under our LUPA was equal terms. And so to have an equal terms argument under our LUPA, you have to demonstrate that you were treating, or that the municipality was treating a religious land use worse than a comparable non-religious land use, whether or not the discrimination imposes a substantial burden. So when we're talking about equal terms, we're not talking about substantial burden. But here you have to have a comparator. You have to have some other entity or organization that's close enough to what you are operating as that you could say, we are being treated differently than this person. It's kind of, it goes back to what we were talking about earlier with precedent. It has to be similar enough that really the only difference is that one has a religious aspect to it and the other doesn't. Here, the court said that the school could not find a comparator that would justify that they were being treated differently because they were a religious use. And it didn't put a substantial burden on their use of the property because they had never operated at night. They could still operate their games during the day, their matches. And the other schools that they referenced that as comparators were in different zoning districts and had different master plan requirements. So the court found that they couldn't justify why it was an issue in this situation. And then I'll just really, because I think we'll be seeing this one again. I thank you all for sticking with me for a few extra minutes. Indig versus Village of Pomona. So this is kind of like the foil case that I talked about earlier, where I didn't bring it up for the law of it, but more just like for your awareness, because this case hasn't been finally decided. It was determined there were some issues of fact that required a trial, so that's still going to be ongoing. But basically what was involved here is that there were certain municipal officials that were accused of discriminating under the Fourth Amendment Equal Protection Clause and also under the Fair Housing Act. The claims were dismissed against certain municipal officials, but not against others. And so I just think you should all be cognizant of the roles that you play, and that what you say in one capacity can always be reiterated or misconstrued in a different capacity. And I'm not, there's no final determination on the merits of this, like I said. And so I'm not trying to comment on that, but it's just something where you should just always try to be aware of what your role is, because you come across challenging applications and situations in all of your municipalities in certain regards, and you don't want to be questioned as to the intention of your actions. So that's all I'll say about that, because we're already over. And but I suspect maybe by next year we'll have a final decision on this one if it hasn't settled.
All right. All right. Well, thank you very much. As you point out, we're a little bit over 9 o'clock, so I'll just wrap up quickly, but I'm willing to stay on. And I think, Christie, you said you're willing to stay on.
Absolutely. Yeah, I'll happily stay on.
Just remind everybody that I will be sending out an email to everyone because I'm obligated to. But the attorney affidavit, the attorney affirmation form just needs to be returned by attorneys looking for CLE credit. If you want a certificate of attendance, please email me, but give me a few days. In fact, next week is a short week, so I'm not going to even promise it'll be next week. It might be after that. And then lastly, I'll just say thank you. Thank you to everyone here, particularly to Christie for generously giving up her time twice a year for this program. Thank you for all the people who are interested in your communities, and particularly the people on land use boards. It's a thankless job, so I try to say thank you at every one of these. So thank you very much for donating your time, not just tonight, but every other night when you're in front of those public hearings. And hopefully you listen to what Christie has to say, and nothing that you do will end up on a future presentation of hers. So with that.
Just to clarify one thing, though, people can bring lawsuits about anything, right or wrong, right? Like, so I just convey why things happen, like what happened based upon what the court said. But if I have an opinion about it, I share it. But for the most part, just because hopefully you don't end up in that situation, but it doesn't necessarily, it may just be an inevitable reality of all the things that you guys do, you know.
Yeah.
So,
Well, you could do everything right and still get sued, but
yeah.
then it might not be that interesting. It might not make the cut for next year's presentation. So with that, I know people are going to start dropping off soon. So
I'm happy to hang out for a few minutes.
yeah, okay. There was a lot of chats. Let me just see if there was any questions in there. It looks like a lot of thank yous. I can't quite, hopefully there's no questions. But there was a question in the Q&A. This is going back to when we had a bunch of questions about both use variances and area variances. The question is, I thought the ZBA is not supposed to consider the personal situation of the property owner. Given that variances run with the land, shouldn't they be based on the unique conditions of the property or the structure on the property? Property owners come and go.
I don't disagree with that. I think that it's absolutely true that variances run with the land. But the reality is that the only reason why anyone wants to do anything that needs a variance is in some way personal to them, right? Whether it's monetary or whether it's familial, there's always, or your house burned down, God forbid, you know, there's always some sort of rationale why you need to do something that requires an area variance. And one of the criteria for an area variance, like I mentioned, is whether the benefits sought by the applicant. So that is one of the parts of the second criterion for an area variance, is whether the benefits sought by the applicant can be achieved. And so the benefit has to be identified, and also in the context of whether it's self-created. You know, if you want to do something to your property that doesn't comply with the zoning code, the hardship is self-created. And so those are things that I think inevitably have to be and are already considered as part of the area variance criteria.
Okay. Someone earlier asked about getting more info on the Monroe case that you had cited.
Oh, sure. County Monroe. That's sure. I can actually pull that up. I can send it to you, Adam. I don't know, or how do you want to?
Yeah, I have the person's name, so if you have something, you can email me. It doesn't have to be right now. If you just want to email to me, I can forward it to the person who was asking for it.
Yeah, it's pretty much the quintessential case on the analysis of determining whether a municipality is bound by its own zoning or another municipality's zoning. And so in the case I was talking about, it was trying to be applied to a different context, and because it was one municipal board trying to bind a subsequent municipal board, and the court ultimately said that they couldn't do that for the reasons of contract zoning and for the term limit rule. But yeah, so I just want to be clear that the court case I talked about, which I thought there was a question about how do I decide what cases to talk about.
So someone put that in the chat. How do you decide what legal cases to cover?
I mean, honestly, I skimmed through every case that's come out on zoning, planning, secra, or lupa that like in the last 6 months every time I do this. And I have to sometimes decide what raises the issues that I think are most important to the board members in doing their job and that are going to be most interesting and applicable, and also to lawyers and planners and everyone else involved in this community. So sometimes I do have to pick and choose because, I mean, look, I mean, it's cut out probably the entire litigation section and we still went over. But that's basically where I start. And then it's what do I think would be most informative and helpful for the board members and most relatable, I guess.
Okay. Someone also recommended that you check out Frankel v. Ramapo Planning Board decision, where I'm not sure what OB approval of religious school was overturned because of lack of hard look. It's a good example and need for boards to substantiate decisions. I'm not sure if you're familiar with that, Frankel v. Ramapo. Planning board, not OB, planning board. So, another question in Bally, why would the planning board not give applicant time to respond letters without reopening the hearing?
Once the public hearing's closed, it's hard to reopen it. You have to renotice, you have to, or they didn't want the applicant to have an opportunity to respond.
Okay.
I can't speak, I can only speak to what's in the cases, but, sometimes it's an oversight, sometimes it's, sometimes it's political or logistical. Sometimes they don't realize that it's a problem, or it might have been something where by the time it gets to the court, the applicant makes a bigger deal out of it than it actually was, and the court doesn't really understand it from the context it was in.
Okay. Someone actually.
How do you spell Frankel? Frankel.
That's what, yeah, in the chat, that's how it was. All right. I don't normally do this during a webinar, but someone raised their hand, so I'm going to hit the button to allow them to talk. Since we're past our official time, I figure it's okay. But normally I would not do this during a webinar because I can't have 20 people talking all at once, possibly. So, Mr. Monty, I've unmuted you. I think I have.
Hi, James.
Still there? Okay. Well, I'm not hearing anything, so let me check the chat again. Oh, there we go. You might be muted still, Mr. Monty. I haven't been able to hear you. All right. Can't hear you. All right. I'm not sure what's going on there. So, all right. So I'm just.
So the one thing I'd just like to clarify, based upon the decision and order that was in the chat that I just pulled up for Frankel, F-R-E-N. I only look at appellate division level cases. If I was looking at like the Supreme Court, which is the trial court, there would be hundreds and hundreds of hundreds. So that's why I didn't come across this decision, because it's a Supreme Court case.
Okay. Someone else put in the chat confirming if a planning board does not act after 62 days after closing a public hearing, is the application approved or denied?
No, it's for the zoning board, and it's a default it's a default denial.
Okay. There were a lot of chats, so if anyone had anything in the chat, it's hard to see. That's why I like to use the Q&A function, because it does stick around. So I don't know if anyone else has anything else they'd like to ask. The question was about the planning board. Okay, that was in the chat. So we're down to our less than 50% participants. We had over 100 at this, so we're about half the people. So again, I'd urge you, the question about the 62 days was about the planning board.
Yeah, I don't think there's a comparable rule for the planning board. I think it only applies to the zoning board, but I can double check the statute on that, and let you know, Adam, if I find anything different.
Okay. All right. So are there any other topics that anyone of the remaining people want to ask Attorney Addona before we say goodnight and give her a chance to rest her voice finally?
Yeah, I apologize for.
You've been talking all night. I can only go a few minutes before I get hoarse, so I'm impressed. All right. Well, again, I said thank you before, but I'll say it again. Thank you very much, Christie. I appreciate you doing this for us twice a year. You in a unique position. I mean, you're doing it solo and twice a year. It's more than any other presenter that we have. So I appreciate it. I appreciate everyone who was here and particularly the people who stuck around. You're definitely the coolest one in
Yeah,
the group.
thank you.
And I think at that point, unless there's something in the chat, thank you, thank you. Oh, you're very welcome. So I think
You
with that,
guys, Adam, you can always reach me, and you have my contact information. Everyone who was who
yes,
attended tonight, I'm happy to chat with you. And we've been trying to do this balance of the in person or via Zoom, so it was kind of nice to have this little informal chat afterwards, because it kind of feels more like an engaging thing, which is what I appreciate about when we'll be doing it in the spring in person.
yes. I mean, it's certainly nicer to have people asking questions than to just have crickets, I think. So it's gratifying for me too. So thank you everyone for all your thoughtful questions and comments.
Absolutely. Happy holidays, and see you in the spring.
All right. Thank you very much. And with that, I will say goodnight and we'll shut this down if I can figure out how to do that. All right.
We've come a long way though since we started this, right? Like during the pandemic, doing it by Zoom.
Yeah, that's true. I mean, well, like I said, I'm trying to do a balance of a mix of in-person and Zoom. So
No, I know, but like I think you had like Cornell kind of
yeah, well,
orchestrating it. Like
yeah, well,
now you're a well-oiled machine.
I don't know about that. Yeah, gotten most of the bugs out of the system, I think. All right, I'm going to stop recording now.